When you fall in love with an Australian, the goal is pretty simple. You want to start your life together here. But then you see the price tag for a partner visa application over $9,000 and you realize you need a plan. We recently met a couple in this exact spot. A Japanese applicant, an Australian sponsor. They had a genuine relationship, lived together for a year, and were ready to apply. But money was tight, and his working holiday visa was running out. So they did what millions of people do every day. They opened ChatGPT and asked for advice. They thought they were finding a clever workaround. Instead, that free advice led them into a legal minefield that nearly forced them apart. Today, I'm going to share their story not to scare you, but to show you how a small mistake can trigger something called a Schedule 3 and how we fought to fix it. Just quickly before we start, this is a disclaimer. The story I'm sharing and the information in this video is for general information only. It is not legal advice. Australian migration law is incredibly complex and changes very often. If you're in a tricky situation, please do not rely on a video or an AI bot. Consult with a legal practitioner about your specific circumstances. Let's go back to our couple. The applicant's working holiday visa was expiring, and they hadn't saved the full application fee yet. They asked the AI for a solution. The AI suggested applying for a visitor visa, subclass 600, to buy more time. Ideally, this sounds logical, but in migration law, logic doesn't always equal legality. They lodged the visitor visa, it was refused. Why? Because the department saw he had a partner here and clearly didn't intend to just be a visitor. Panic set in. They went back to the AI. It told them to contact the department. They did, and they were advised to apply for a bridging visa E, BVE, to stay lawful. They thought, okay, we're safe, we have a visa. A few weeks later, they finally saved the money. They logged on to apply for the partner visa, ready to celebrate. But then a warning message popped up on the screen. The message said the applicant does not appear to hold a substantive visa. Schedule 3 criteria may apply. This is where things get technical, but stay with me because this is crucial. In Australia, to apply for a partner visa onshore without extra hurdles, you generally need to hold a substantive visa. That's basically any visa that's not a bridging visa or a criminal justice visa. Because our client was on a bridging visa E, he was not holding a substantive visa. By applying for the partner visa at that moment, they triggered Schedule 3 criteria. Schedule 3 is like a gate that slams shut. To open it, you have to prove compelling reasons exist to waive the requirements. The bar for this is incredibly high. It's not enough to say we love each other or we didn't know. The AI didn't warn them about this. It didn't know that a visitor visa refusal leads to a bridging visa, which leads to Schedule 3. The heartbreaking part of this case is that it was entirely preventable. When they first sat down to solve this problem, they had a golden ticket that they didn't see. The applicant was Japanese. He was eligible for an electronic travel authority, an ETA. Before his working holiday visa expired, he could have simply taken a short trip, maybe to New Zealand or back home, and return on an ETA. That would have given them a fresh 3 months on a substantive visa. They could have lodged the partner visa onshore then, with no Schedule 3, no waivers, and no risk of separation. A quick consultation with a professional would have identified this in 5 minutes. But the AI missed the complexity of his nationality and visa history completely. So what did we do? They came to us at Flow Migration Law, devastated. They thought he would have to leave the country and face a 3-year ban. We chose to fight. We sat down, built a massive submission. We had to prove that their circumstances were compelling enough to override the strict regulations. We looked at everything: the financial hardship, the emotional impact, and the nature of their bond. It was a long, hard battle, but eventually the department accepted our arguments. The waiver was granted, and their partner visa was approved. They are now building their life together, safe and lawful. Here is the takeaway. AI is a tool, not a lawyer. It can give you information, but it cannot give you strategy. It doesn't care if you get rejected. Immigration law is a puzzle where the pieces change shape depending on who you are. I've spent over 8 years as an Australian migration lawyer, and I have seen too many good people get into bad situations because of poor advice. If you're worried about your visa pathway or you've hit a roadblock like Schedule 3, don't guess. Let's look at it properly. You can book a consultation with me directly. The link is in the description box below. Let's make sure your story has a happy ending as well. Thanks for watching.